Hello, Attorney AG Konstantin with Litherland, Kennedy and Associates, an estate planning and elder care law firm. Today's topic, Proposition 19, just the basics. We could talk all day about Prop 19. I'm here just to give you a quick little glimpse of the basics. And when we talk about Prop 19, what are we really talking about? We are talking effectively about the parent-child exclusion. So Prop 19, as you may remember, it narrowly passed in the November 2020 ballot. The controversy surrounding Proposition 19 deals with the severe restriction that it placed on the parent-child exclusion. In order to fully understand this topic, it is best to go through a brief analysis regarding property taxes. You see, there's a considerable difference between the fair market value of a property and its assessed value. The only time the fair market value and the assessed value is the same is on the day that you acquire a property. Thereafter, these two numbers become further and further apart, sometimes in your best interest, for example, when we're dealing with property taxes, and sometimes not in your best interest, such as when we are discussing capital gains, a topic we cover in more detail during other presentations. The fair market value is the price that a buyer on the street is willing to pay for your home on the open market. The actual price that was paid by a buyer on the market becomes that individual's assessed value going forward. While the fair market value can fluctuate up or down a rate that is only controlled by market forces, the assessed value does not fluctuate nearly the same on average. In fact, since the passage of Proposition 13 in 1978, the assessed value of your property is capped at 2% annually. Now let's take a look at an example. 40 years ago, you purchased your home for $80,000. On that day, both the market value and the assessed value is one and the same, that is $80,000. In the ensuing 40 years, however, the market value is now $2 million, while your assessed value, capped at 2% annually, is only $200,000. I think you would have to agree that's a big difference. Now, why is this important? What do you need to know? Well, prior to the passage of Prop 19, you were able to pass along your favorable low property tax base to your children, thanks to what I call a companion law to Prop 13 called Prop 58, 1986. There was also a parent to grandchild exemption as well. But again, let's just focus here on the parent-child exclusion, which has been severely restricted, as you'll learn a little bit more now. So it's not important that you memorize these laws by the numbers, right? But what is important to note is that Prop 13, the 2% cap on property taxes, is still good law. That hasn't changed whatsoever for your purposes. What has changed as a result of Proposition 19 in 2020 is the limitation it placed on the parent-to-child exclusion, which is what we're leading up to here. In our example of your assessed value being 200,000 when the market value is now $1 million, you're paying property taxes on the 200, right? Not the 1 million market value. What we're talking about now is that reassessment to market value after your death when that house is passed along. So up until when the law went into effect, Prop 19 passed in November 2020, went into effect February 2021, your children would have also been able to keep those lower property taxes. That's the bad stuff about Prop 19. And what I will say at this point also is that if you don't have children, by the way, Proposition 19 is your friend. Proposition 19, for those of you without children, was of no real impact to you whatsoever. So let's talk about what happens now with Prop 19 for those of you trying to pass on a house or your primary residence to your child. First and foremost, in order to do it now, it narrowed it. It doesn't mean we can't do it. It's just narrowed. And here's what it looks like. First and foremost, that primary residence of yours has to, in fact, be your primary residence. And then it must become the child's primary residence within 1 year. And the value, by the way, is limited to the current assessed value plus $1 million. And finally, this exemption must be claimed within 1 year. So what does this mean? Well, it means that your residential rentals are going to be reassessed at your death. Commercial property rentals that you may have, again, reassessed at your death, as would any investment rentals that you may have at the time of your death, including a family vacation home that could have been in the family for generations. Your home, your primary residence, will also be reassessed at death if a child does not make it their primary residence with the limitations we discussed. Your home will also be nevertheless partially reassessed as death, even if a child were to move into it, if the home fair market value exceeds the assessed value plus $1 million. All right. Now, I'm telling you all the bad parts about Proposition 19. Again, for those of you without children, this could be your best friend, because there are some very positive things that also came out of Proposition 19. Now, let's talk about those. And now, I also want to remind you, though, as I get into this, how this proposition even came to pass. First of all, the title of that proposition back when it was on the ballot. That title read, "The Home Protection for Seniors Severely Disabled, Families and Victims of Wildfire or Natural Disaster Act." Now, if you didn't know what lied beneath those eloquent put words, of course you voted yes for it. Secondly, $50 million was put up into the campaign to get it passed, and almost no money was spent to oppose it. Prior to the passage of Prop 19, when Propositions 60 and 90 were still applicable, if you were 55, you could only sell your principal residence one time and move to another home of equal or lesser value, but only in your same county or in one of those very few counties that also participated in intra-county moves. Again, those were very limited here in California. But now, again, we're discussing the positives of Prop 19 right now, right? Now, if you're 55 or older, disabled, or a victim of fire or natural disaster, you can now move your primary residence up to 3 times anywhere in the state of California and maintain your low property tax base. Why 3 times? I don't know. That's what the law says. You can purchase another residence that is lesser value or even added value. And the way that would work is if you sold your property, here's an example. Let's say you sold a property for $2 million and you bought one for $3 million. The first $2 million of the new property taxes would mirror what you had before. That added $1 million that you got, that would just be taxed at the regular rate of the $1 million property tax. And again, if you had purchased something for lesser value, your property taxes would not have been impacted. I hope you got something out of this presentation. Look for other ones to come. Thank you.